you. What I'd like to do this morning is discuss some legal texts that were published in both the 16th and 17th centuries and to continue some of the ideas that were mentioned by Richard yesterday, and that has to do with both printing and the dissemination of printing amongst various communities and how those new ideas that may have appeared in law texts that were published were received. Before we do this, I'd just like to make one request as a technical mistake on my part, but it will make our discussion here easier. If you have to work your handbook in front of you on page 5, 6, and 7, you will see that there's the Siftei Kohen is translated. Instead of numbering it 1, 2, 3, and 4, it will make it easier for our own purposes if you just turn the 1, 2, 3, 4 to A, B, C, D. And then we'll be able to refer to things more easily. So just on page 5 and 7, 1, 2, 3, 4 become A, B, C, D. I'd like to start on page 3 at the bottom, and we'll do a discussion based on the English text, and if once you want to move to the Hebrew text, that's just fine. And I'd like to start the discussion with the Shulhan of Rabbi Yosef Karo. The Shulhan, as you know, has an attempt to codify Jewish law in the mid-16th century, to take much of the work that had been done in the Middle Ages back to the Talmudic period, bring it together in a workable code that can be easily used by those who have some familiarity both with rabbinic Hebrew and rabbinic text. Certainly not to be thought of as a popularization. It's not in a language that most people understand. It's not accessible to everybody. But be that as it may, for those people who have some fundamental education, it is a text that is relatively simple and straightforward. The text is first published in 1566, I thought, but I guess I found 1566 in Venice. And I'd just like to take a moment, I know this is not directly related to the text itself, but to show a tool that's available now on the internet for those universities or institutions that have subscriptions, and that's also a Chachma that appears behind you on the screen. This tool allows you to sit wherever you may be sitting and see the original text online. I was going to discuss an issue of ritual slaughtering, and specifically the blessing before ritual slaughtering. Now, I know this may not be on the radar of everyone, but ritual slaughtering and blessing before ritual slaughtering gives a chance to analyze a legal issue that really is under very little pressure. It's not as if there's been geographic change that changed the nature of ritual slaughtering. There's not climatic change that says, okay, I have to deal with a whole new issue in the act of ritual slaughtering. There is an economic factor, but that economic factor has been from time immemorial. A steer is worth a lot of money. There's no question about it. That steer can feed many people, and therefore is simply a valuable item. That hasn't changed. That's true in the 16th century, true in the 12th century, and in many ways it's even true in the 21st century. A steer, a whole steer that's been raised, is still a valuable commodity. So from that perspective, choosing this issue in many ways removes some of the issues that we always look for from a historical perspective. What causes change? What brings about change? Those external issues. I'm trying to say, it's not an issue that Jews are in a new society. It's not an issue that really there's a different economic climate. I think here we can more or less concentrate on some of the legal issues at hand without worrying about some of the external factors. So that's why we've come to ritual slaughtering. Rabbi Joseph Karo writes the following. The ritual slaughterer should say the following blessing before performing the act of slaughter. I filled in what he assumed. Blessed are you, Lord our God, King of the universe, who has sanctified us through his precepts and commanded us regarding ritual slaughter. And if one slaughtered and did not make the blessing, the act of slaughter is still acceptable. Now, this is pretty straightforward. However, Karo, as in any legal code, has left certain ambiguities. And glossators come along and pick up on the ambiguities and try to fill them in. If you turn to page 1, you come to the commentary of David ben Samuel Halevi, who lives between 1586 and 1667, and in this time there's just has published his book, the Sefer Turei Zahav, or the Taz, as he's called by the acronym, Lublin in 1646. And he tries to fill in a small blank here. If you sort of keep one hand where we were, you'll see that Caro said that if you didn't make the blessing, the act of slaughter is still acceptable. Well, one issue that hasn't been totally flushed out yet is what happens if somebody didn't say the blessing on purpose? What happens if he really didn't want to say the blessing? He didn't say it. That's what David ben Samuel Levi comes and tries to deal with. And here he states a number of things. In the first part of this comment, he quotes what was known as the medieval Ashkenazic position. And it cites a number of people, including Mordechai ben Hillel, Eliezer ben Yoel HaLevi, who all say that, you know what, it's not really such a good thing to let the slaughterer himself eat from it, but other people can eat from it. Second part of the comment, he brings in something that's found in Rabbi Joseph Caro, who cites Maimonides from the Sephardic world, who disagree. In the third part of the comment, he said, but my own teacher, his father-in-law, Rabbi Joel Sirkis, who was the rabbi of Krakow and had died in 1640, he said, nevertheless, we should be stringent and fine the ritual slaughterer based on this earlier custom. And here fine means certainly no less than not letting him eat from the meat, and whether it means more from that depends on other things. Now, this gets a comment from Shabtai ben Meir HaKohen, who you have on page 5. Now, Shabtai ben Meir HaKohen publishes the work in 1646 in Krakow. And you notice his date of birth. This is a kid. I mean, he has come and essentially challenged one of the outstanding rabbis of the age. Now, if the book is published in 1646, it didn't get written in 1646. There is certainly a gap. There are no less than 18 different approbations on this book. Now, that's very unusual to have 18 approbations on a book. And the reason is very clear. There was great resistance to publishing a book of essentially a young kid. Who is he to come along and say, I'm going to challenge what other people have written before me? He's just basically, just a little kid. What right does he have? It took 18 rabbis to sign off on this approbation for the book to be published. But published indeed it was, and it's become to this day the basic work used in the study of these topics. He too deals with this issue of what happens if someone purposely did not say the blessing. He says the meat's permitted to him, and this is how Rabbi Joseph Caro ruled, Moses Isserles ruled, Solomon Luria ruled, but he does cite Rabbi Joel Sirkis' view, and he says he didn't view in this way, and then he cites himself. He says, see what I wrote in the beginning of section 28. In section 28 he basically writes that the slaughterer can eat the meat unless we know he's really going around and nobody's doing this, nobody's saying the blessing, everyone's not wanting to say the blessing. If we have a real social problem, then we'll not allow people to use it. But otherwise, it's okay. Notice in these cases that basically they're relying upon texts that are known within the Ashkenazic world. With the exception of Yosef Karo, the texts that are cited here are all texts from within the Ashkenazic world. Let's move on to the second part and the gloss of Rabbi Moses Isserles on page 4, the top of page 4. And if one slaughtered an animal in which there was some doubt regarding its acceptability, and there is need of an internal examination of the animal to determine that it is kosher, one should slaughter the animal without making the blessing, and if one finds it to be ritually acceptable, as after doing all the checking, one should then make the blessing on slaughtering, so long as it is not long after the act of slaughtering. So you have a doubt. In order to prevent mentioning God's name, saying a blessing in a place of doubt, don't say the blessing. Do the slaughter, check the animal, and if it's okay and not too long has passed, you can say the blessing. I'd like to turn to the comment of Shabtai ben Meir HaKohen on this issue. Moses Isserles, leading rabbi in Krakow, dies in 1572.
His comment, certainly into the 17th century, well known, people are using it, so this gets picked up. He says, here he cites, in comment, what's printed here, 3, but you can see the C, that's where it appears in the gloss, okay? And Rabbi Moses Isserles in his Darkei Moshe cites in the name of Rabbi Israel of Krems that even when slaughtering a presumably kosher animal, if the slaughterer forgot to recite the blessing before slaughtering, the blessing should be said after slaughtering. And he cites a number of other sources, but then further down on the page he says, but Maimonides doesn't think so. Maimonides says if one slaughtered without first reciting a blessing, or for that matter, even if one separated priestly ties and ties to the Levites, or ritually immersed and did not first recite a blessing, one does not subsequently go back and recite a blessing after doing the precept. And so too in all similar matters. Maimonides says if you did it, you did it. Now comes what I think is something that's a little unusual. And Abraham Trevis, in his work Birkat Avraham, which is published in Venice, disagrees with this. And now we get a discussion whether who is correct here. And he goes on, and you can see that about 6, 7 lines down from the top, Siftei ben Meir Cohen adds, in my humble opinion, all of Trevis's views do not make sense, for we have certainly learned that all blessings except grace after meals are rabbinic decrees. We have some sort of discussion going on here. This is an internal legal discussion. But as this discussion progresses, we get some rabbis cited here who we don't traditionally see within the Ashkenazic world. As we go on, we go to the next page, we see Rabbi David Abu Draham, who cites Rabbi Zrachia Halevi. David Abu Draham, we have little notes here at the end saying more or less where these people lived. 14th century Spain. Cites for Zrachia Halevi, who lives in Provence in the 12th century. We get a citation of Isaac Alfasi, who is cited in Ashkenazic literature, but through Rabbi Moses Al-Shakar, or Al-Ashkar. Now, these sources that he's citing here are not traditionally found in Ashkenazic sources. And here, I admit to a methodological conundrum that's certainly a stage along the research, certainly not finished. The way that I've tried to see whether these people show up is by doing searches in databases. I've tried to see who cites these people. And if we run a search through the databases, we'll find that these people are cited. For example, Abraham Trevis is cited first in the Ashkenazic world by none other than Siftei ben Meir Cohen. He is the first person to cite this work. And since my computer luck has been limited today, I'll go back and do a few searches just to show some things I've done. If we come to Al-Shakar, we'll see that nobody quotes him until Siftei ben Meir Cohen. We see here that he cites the rulings of Rabbi Menachem Rekanati. Rekanati is first cited in Ashkenazic sources in his legal works. I'm not talking about his Kabbalistic works. His legal works are first cited by Siftei ben Meir Cohen. That doesn't mean they're not aware of him. Certainly other people are aware of these people. Shlomo Luria, who's writing in the mid-16th century, cites Rekanati in a Talmudic commentary, but not necessarily in a legal work. That is to say, a work of how practical law. They're known to these people. Moreover, if we look at if it's too far from here, then there are two screens in the back if your eyes are not perfect, mine are not. If we take a look here, we'll see that these works have been published. Abraham Trevis's work was published in Venice in 1552. Menachem Rekanati's work was published in Bologna in 1538. Jonah Garandi, who is quoted here and is popularly quoted in Ashkenazic sources, was published in Constantinople in 1509, Venice, Salonika, Fez, Savonietta, Villa de Trento, and eventually in Krakow. But he makes sense because his teachers came through the Ashkenazic French, basically from the world of the Tosafos. So if they came through part of the tradition, it makes sense they're going to quote him. Moshe al-Shachar, Spain, published the Gurion 1554. He's really from the Sephardic world, Spain, North Africa, Jerusalem. And David Abu Graham is a student, again, of an Ashkenazic individual, so he gets picked up a little bit. But the Sephardic world had not been picked up. The books were out there. It's not as if they didn't cite other books from Italy at the same time period. But these books do not enter and filter through into the Ashkenazic world, essentially, until Shabtai ben Meir comes and quotes them and integrates them into his work. Now, he does not give the same weight in every single section of Shulhan Aruch and his commentary to these works, but he does cite them. And this is a break. Rabbi Moses Israelis writes in his commentary to the Darkei Moshe, which is an introduction to Shulhan Aruch in many ways. These are the works that he relied on. We're talking about 1550, 1555. Sitting in Krakow. He relies on the Talmud, the Gaonim, Rabbi Isaac Alfasi, the Tosafot, Maimonides, and that in itself is rather innovative because in the 15th century, Ashkenaz rabbis did not like Maimonides because he doesn't quote sources. Rabbi Yisrael Esterline says specifically, I do not want to use Maimonides because he does not quote sources. Rabbi Israel of Krems, 14th century Austria, in the 15th century, and Jacob ben Asher, and Mordechai ben Hillel, also from classic, these people, classic Ashkenazic sources. This is what he used. Along come some people, by 1550, and say, look, some new books have been printed. And they asked him to include some of these new books. What are these new books they asked him to include? They asked him to include Rabbi Yosef Colon's book that gets published in Venice in 1519. They asked him to include the works of Jacob Molin, Ashkenazic authority, that get published also in the first half of the 16th century. But popular opinion on the street didn't include new books. Israelis writes that if you ask people, Marvel Bahume de Ame, it's a pearl of wisdom in the mouths of people. That who do you cite? Mordechai ben Hillel, classic Ashkenazic authority of the 13th century, 14th, Israel of Krems, and Jacob ben Asher, author of the Torah. There is a canon of people you use. In the legal field, writing in Ashkenaz in the 16th century, there are people you use. A scholar like Rabbi Moshe Israelis might use a little broader, and people may think it's much more circumscribed. But he uses a very limited set of sources. When if we go back, we see that other sources were certainly out there. Shabtai ben Meir, a Kohen in the middle of the 16th century, comes along and says, in the middle of the 17th century, comes along and says, I'm going to expand things. I'm going to use more. He opens up these books. Now you might say, why? Well, I want to come back to the point of his age. He's a young man. I assume he finished the yeshiva, entering the court system as a judge. He's incredibly inquisitive. He checks everything. He's looking everywhere. He'd argue with his mother, for goodness sakes. He is in search of what he thinks is truth. He'll go to any end to check it. All of a sudden, we have all these works that people would not quote. People like the Ramchaz, David ibn Zimra, from Egypt, the Rashdam, from the Medina, the Turk Ottoman area. All of a sudden, they're entering into the Ashkenazic parlance. However, the fact that they're all of a sudden cited within these commentaries doesn't mean that it's changed the world. The only way to really check whether there's an influence is to see do other people follow in his wake. The books are obviously there. We even know someone who sits on the court with him and writes a book at the same time. So we know that other people have access to the very same works he does. But do they cite them? And again, by using the database, we can find that what happens is, This is almost a one-shot deal. Shulhan Meir Cohen introduces the Ashkenazic world to all sorts of new sources. But the people who follow, people who are older than him he is in many ways, people who follow him don't pick up on it. They continue citing the same sources. Every once in a while they'll cite an issue that he raised. If he raised the issue, then they have to deal with it. But they don't integrate these works into their works. In fact, the integration of Sephardic works into Ashkenazic works really doesn't take place until the 18th century. They continue upon their own, I don't want to say narrow, but let's just say their own merry way. They continue working within a known legal framework. Israel Tashma wrote an article in 1975, published in 1975 in Kiryat Sefer, where we discussed how some Sephardic authorities came into the Ashkenazic world. He claims that it has to do with printing, that these works really weren't available enough until the 18th century. I'm not sure whether printing is really the issue. We see from at least from Siftei and Yoreh De'ah, these works were available. But I think there's also a mindset. When we discuss the early modern period, I think we also have to discuss that the early modern period not only has geographical tracks, that is to say that certain countries change at different rates based on their exposure to things, but even within countries, within cultures, there are different cultural tracks. And law tends to be a very, very conservative cultural track. These people may give their classes in yeshiva with certain ideas, certain new ideas. They may be exposed to them in discussion. But when they write legal tracts, they stay upon what is well-trodden. The well-trodden path is the path that's known, and that's the path that was accepted by their teachers. A young kid comes along, he's almost unfettered. He writes, he searches everything. He brings it all in there. But when others come to follow in his way, unless he's raised some great issue from these texts that has to be addressed, they ignore the texts. They may cite once in a while. The texts are out there. There's something on point. They may refer to it. But there's no systematic attempt to go through these works. The fact that Shakar's work, for example, has no resonance in Ashkenazic material till the 18th century is astounding. We're not talking about a rabbi of the second class. We're talking about a first-rate jurist. Nothing. Even someone like Rabbi Jonah Garandi, who does have Ashkenaz credentials, so to speak, even he is not picked up widely. Even someone like Rabbi Zrachi Halevi, we said before, people quote, he's out there, but nobody quotes him. Nobody in all the literature quotes him as much as Rabbi Shabtai ben Meir Cohen quotes him over 300 times. Of the 500 citations, 300 are by him. This is a man who revolutionizes Jewish law. But that revolution doesn't really take place until much, much later. It's there on the books, but it'll take a while till it's internalized. So that's the sort of material I'd like to put on the table for discussion in the sense of law. In the early modern period, that law may be something that's a little slow in becoming early modern. And I'd like to take a moment, if I can, just to show you one or two sort of searches, what I did methodologically, and then we can have a little discussion. So this is the Bar Ilan response program that you all know and love. And what I've done was, I've taken the databases, and I've essentially taken Yom Shol Shlomo, Rabbi Shlomo Luria, Marsha, Shlomo Yudlis. These are commentaries. I threw them in just to make it interesting. If we go down, we take the Shulhan Aruch. I put in all the Shulhan Aruch. I took the works of people who lived both before Rabbi Shabtai ben Yoreh Cohen, Smav of Shul Falk, Shach himself, people who come after, Avram Gombander. And to add a few more things, I've gone also to the responsa and put in people who come both before and after. Now, as you all know, I don't have to tell anyone this, if you put in a phrase like Birkat Avraham, you have to, the title of Travis's work, you have to be a little careful, because that's also a phrase that appears in the liturgy. So you have to weed some of those out. But you can see right away, even if I come up with 6 results, and only 3 of them, both Neshach, and then one gets picked up in Magen Avraham, have anything to do with his work. So that's one example. Al-Shakar, I pick up, again, I have 88 citations within Shulhan Aruch. I'm going to have to be careful, because the Shulchan Aruch itself, it still didn't work, so what can I do? One of the advantages of showing you the original was it didn't have all those little references to where these things are cited. The Bar Ilan project does. I have to ignore all of those. Again, if I go through, you see the Shach comes up immediately as being... You can see the Shach comes up immediately as being the person of Shulchan Aruch, but this is a reference citation that comes much later. It's the Shach. He introduces these people. After the Shach, almost doesn't get picked up. So that's just a methodological tool that I use to try to weed these things out. Now, this doesn't take into account the place of these people. You may say, okay, so he gets cited once, it's a nothing citation. You're right. And there's sometimes it's a nothing citation, but there's sometimes it could be a revolutionary citation. So that's a problem with the quantitative approach, at least at this stage, but some of them are serious discussions. Those serious discussions, of course, are new in the Ashkenazic world. They just don't seem to move on. But that makes sense.
Thank you. So I think my role is to give an outside perspective. So I'm going to give one that's conceptual and not remotely historical. But you said that this is maybe law is slow to become early modern. This pattern seems so typical from other legal cultures, what you're describing. I'm just reminded of the recent issue about citing foreign sources in constitutional lawmaking on the court very recently. And the first thing that happens after the court has this, what is basically meta-halachic or methodological debate about whether you can cite these foreign sources to illuminate American constitutionalism, the first thing that happens is that scholars go back. It takes a long process and start to develop different jurisprudential theories to justify it, and to do historical work to try to see who did this before and whether this in fact is common. And it's a kind of slow process of changing what you can cite, because after all, what you cite, right, that's where authority contests are. So that becomes the most crucial issue. Now, you mentioned the curiosity of youth, but what also seems to strike me about this is the anti-authoritarianism of youth, because it's a very bold move.
No question. That's spoken as a good mother. Yeah, there may be a side here of rebellion. I don't know. But,
and then you would see it would take a long time before the novelty of this, the rebelliousness of this would somehow ease off, and you get more discussion going about whether this is okay or not, and you sort of expand the canon in that way.
just to add one, the people who really pick it up are the people who, in many ways, revolutionized thinking again in the 18th century. So it takes a while, and again, it takes people who are willing to push forward, willing to take it forward.
I'm sorry that I came late. It was not willingly, but at any rate, and I hope I'm not repeating something you said or making a distinction that you already made, and if so, you'll tell me. It's very interesting. You mentioned that how conservative law is. Now, if we look at the 12th century, look at the way the Ramban picks up on Rabbi Tam's revolution. And nevertheless, despite that, if you take a look at Zahab-The's new book on the Ramban, you see that despite the fact that he's willing to use all these new methods of analysis and commentary, when it comes down to law, he will stick with a riff against everybody. And I think that too, in other words, it's not just a matter of some people are slow to pick up. In some areas they're slow, in some areas they're not slow. The Ramban picked up on the Tosafist revolution immediately, but when it came to applying it, the halacha l'maisa, no way.
Legal discussions are one thing, legal applications another. It's no surprise to me that people are slow in picking things up. But this information is out there, and it takes a while. But once somebody integrates it, you see even then. It's not picked up very quickly.
You mentioned, I mean, since a lot of these authors, state you mentioned in their introductions, this is the sources I chose, these are the ones I'm focusing on. Do you pick up after Kohen any overt voice of resistance to what he's doing? Someone saying, we don't look to those authorities, or this isn't something that should be done. Do contemporaries notice what he's doing and respond, or do they respond just by kind of ignoring or not noticing the change?
Well, the first one to notice is, of course, none other than the Taz. Here's an older man, and this young whippersnapper came along and did all this and wrote, and he's outraged. But he's outraged on many levels. But he also, this is not the way things are done. But he doesn't, I haven't found, that doesn't mean he doesn't say, I haven't found a place yet where he writes specifically that I reject all these new sources that he's brought in. That I haven't found yet. And of course, the Shach himself does respond to the Taz in writing thereafter. So they have a little give and take. But I haven't found someone who's come out outright and say, there are other people here who have certainly gone through this material more than I have, and they may well know the places where they respond, where there's an outright saying, we reject it. I don't know anyone ever came along and said, I reject what the Shach did.
I would like to go back to where Susan left off. Suzanne, I'm sorry. Suzanne left off because I think that she put her finger really on the issue with the contrast with the Supreme Court that we all know. And in terms of legal, not dissemination, but reception and passing on, there's so many factors that are going to work in here. We like to think of, the Rambam wrote, and therefore everybody saw, and Rashi wrote, and Rabbeinu Tam, and everybody saw. But first of all, it begins with the fact, look at the court itself. How many of those people are capable of that meta-legal discussion that are sitting on that court? I don't think all of them are. Second, there's a certain xenophobia in law, which you began to mention. I read a little bit of this debate about should we bring in foreign sources? Oh my God, no, we have to be pure Americans. What the hell does that mean? Excuse me. And then it's a lack of knowledge, because if you read the Federalists, if you read the American founders of the Constitution, they knew European law, I do believe. And they were. It's already embedded in the American tradition in some ways. There's a great article in the New York Times about how to read the Second Amendment. And he said it's an ablative absolute, that crazy clause, the right to bear arms shall not be impeached or something. And it made perfect sense. So there's so many things and of course the fear of innovation and ideological orientation, so that there are 10 million factors why law, you shouldn't be surprised. I think you should be surprised if things are picked up.
I would agree with that, but I would say that all the members of the court understand what's at stake in the debate. It's an authority contest, and they know it. And
that they know, yeah.
I mean, and it's the question of, what sources can be viewed as authoritative, and what theory of the Constitution and how to read the Constitution hinges on that. So it's a huge, very, very important methodological debate, which we all know the methodology of how you do things is much more bitter, a dispute, right? That's where the bitter disputes in law happen. It's the sharpest ones, the most difficult ones, the most vicious ones, rather than substantive resolve. So that's...
I think that's true here too. In Jewish law, I think that's exactly the point. Do we continue the Ashkenazic tradition, the pure, whatever you think pure is, the pure Ashkenazic tradition, just as you stated?
So my question on that, from the historical perspective, is where did these 18 approbations come from? Is there politics behind it? What's the story of that? Because that seems the most curious.
Well, the only thing I can tell you about the story behind it is, from reading the approbations, many of the approbations were garnered at fairs that used to take place in Poland. There used to be fairs twice a year where rabbis and laymen would come. They do their business and they'd also meet. And this is a good place to bring a book if you wanted approbation, because you have a lot of rabbis there. The antagonism to publishing the book was to let young men like this write a book after someone like the Taz, David Ben Samuel Halevi, had just written his. The difference in years, just a year difference.
So you assume that, I mean, let's say, we have this process today, and we know some of the politics about it today. You assume that the work was read or not read before the Haskamas?
Oh, I assume the work was, looks like a good book. You know, and, glance through. How much could you read in a fair? How big a manuscript could you bring with them?
Right.
I want to go back from the meta question to a very specific, maybe to ask about one of those multiple specific factors. You introduced your discussion by saying Siftei was one of those things that seemed
Well, this issue, this particular issue.
relatively stable, and therefore we could kind of isolate other questions. But think about the printing of Shchita manuals. The Shchita of Jacob Weil, for instance, were published, as you probably know better than I, dozens and dozens of times for the actual slaughterers to use. So we're talking about something that in this period has become a kind of mass knowledge almost among that second rank, people who wouldn't necessarily make the laws but are being trained to do slaughtering. So could there not be some kind of resistance to change once things have been taught and set and printed so many times and then studied and learned and put into practical use? That might be one of the sources of resistance to change.
I think it's a very good point that education, when it's done, can be a point of resistance to change.
There's
Just
a
to
professionalization
right.
and a literature for these professionals that might have made it a kind of guild that was impervious to.
I'd be willing to even go that route. And there's no question that these works, not only were they published a number of times in Hebrew, and they were published often, but they were translated into Yiddish. We have Yiddish versions of these. So there are groups of people who know these laws. What I've tried to do is use this as an example, and then by searching throughout the entire corpus of these people's writings, well, how do they quote? Do they quote these sources? So I just use this as sort of an example, and then try to expand upon it. It's true, your point is well taken. Maybe there's resistance to change after this is what people know. But that resistance to change would then say, essentially, that comes back to the whole point of law. In law, there's a resistance to change. Because if we leave the laws of ritual slaughtering, we go throughout all the corpus of Jewish law. They're not quoting any of these Sephardic authorities. Why are Sephardic authorities not being brought into the legal discussion? It seems that it's not just what people do, but I think it's also what jurists do. How do they see the law itself? What are legitimate sources for deciding the law? The Sephardic world, in many ways, had been outside the pale. And now you're asking, say, well, we've discovered these people. Printing has come, we've discovered these people, they're there, and do they have weight? Do they not have weight? It's not just about knowledge, because if it was just about knowledge itself in the discussion, they say, okay, here's a new source, let's deal with it. But there's a resistance. The resistance, I think, that this is not just this case, but other cases as well within Rabbi Shulhan ben Meir's writings show that he doesn't share that resistance. That resistance pervades his contemporaries, predecessors, contemporaries, and successors. It takes a while until it really does filter through.
I want to raise a maybe informational question, which you may not be able to answer, about the material conditions of the kind of research on the part of the chapter described. In the 20th century, if we're dealing with a post, say, who is very broadly read, take Kohen-The, we have some idea of how he gathered that kind of breadth. Went to bookstores, stood in the bookstore. The booksellers had respect for him. They let him stand there, and he sat there. Remember, he imbibed, inhaled the books, and we know that as he had a larger apartment and more money, he collected as well, and he had very good memories. He could actually remember where all these books were on the shelf. If I go back to the 16th century, and it's a question I've asked myself whenever I notice the kind of breadth of citation in the Shach. Which library did he patronize? How wealthy was his father-in-law? Did his father-in-law? Where did he get access to all these books? I could imagine a person of very high intellectual caliber, just as smart as a Shach, without any aversion or allergy to discussing sources that are not known before. The person would simply saying, I sit in my library, I have to deal with what I've got. And something resentful. Somebody new comes in and starts quoting all this. Now, in order for me to psak, I have to be as rich as you, or I have to use the libraries that you go to. What is it may simply be a material foundation which may then generate all kinds of intellectual, historical reverberations, change rules.
Totally is something that I tried to consider. And let's just go back to some of the people who come before the Shach. The Shach himself is in Vilna at the time. Vilna is relatively large community. Everything is relative. But he sits in a place where obviously these books existed. If we go back to Rabbi Moses Isserlis, Shlomo Lurio, or someone like even Benjamin Slonik, these people all spend time also in large communities. Now, Krakow probably would have had the best collection of books given its connections with Italy. And we know that David Darshan says he left 400 books. He was willing to leave a library of sorts of 400 printed books. We know that both Isserlis and Luria had manuscripts as well as printed books. So they had that. Their students, though, had access to copying material. They could copy material from these books. In his introduction to the Chochmat Shlomo, Luria's son writes that he allows people to come and view the books, his father's writings, and see things. And we know that in Luria's own yeshiva, he allowed students to copy. So students in the yeshiva training would have an opportunity to copy books. Now, it could be that, there's no question he has a phenomenal memory. While others were copying, he may have been able to just scan visually. All that may be true. And much what we know from manuscripts, and Reiner has written about this, but it's true if you just sit in the Bodleian library and you look at these manuscripts. People, when they were in yeshiva, copied books for their lives. They copied a little from here. Oh, I'm interested in this. I'll copy from here. And they go home. And this is their book because they don't have printed books. They copy and it continues well after the age of printing. Without a Xerox machine, what would he have done, right? Imagine ourselves. We would have to copy all that stuff. So they copied. Is it true that he had access to more? There's another person who sits on the very same place, on the very same court, and doesn't cite the same breadth of sources as he does. One would have to assume that he had almost equal access in a small community. I can't say for certain that he did. Can't say for certain he did. But they were together on the same court. That suggests that they had equal access. It only suggests, I'm not saying it does, but it suggests. But certainly in Krakow, that would include Isserlis and Benjamin Slonik, who also studied in Krakow as a young man. Luria, we know, had a substantial library. And Luria is generally thought to be a broad-sighter. But they don't, not the same breadth.
Yeah, I'd like to return to the point that Yaakov Elman raised, and maybe, I think I'm being repetitive or redundant, but maybe I can make the point a little sharper and ask you to respond. You set the conversation up by pointing out that the Shulchan Aruch is not a popular work. But I'm not sure that Karo would have thought that. Karo understands the Shulchan Aruch, not the Beis Yosef, but the Shulchan Aruch is something that could be gone over once a month. If you look at the original editions...
By whom?
No, one second. Well, I'll tell you by whom.
He writes them.
One second. But if you look at the additional, at the first editions, it's literally a point. It looks like a table, like a PowerPoint presentation. None of the commentaries are there, right? So, and he says, First of all, when somebody comes to you with a shaila, you won't have to say, "Oh, I'll go look it up." You can answer right away. This is the Zakain. But he says, and kids will learn this. He says, young people. And the third edition, I think, is a pocketbook.
Which kids? The first edition is already a pocketbook.
Huh?
Which kids?
No,
Which kids does he say?
Kids in school. He says
that's the point.
Yeah, no. But then you have to ask how broad is education. But I'm not even sure he would have. When we talk about popular, I'm not disagreeing with your point that this is not a. I mean, what you said was correct, but it's just that I'm not sure he, in the context of his time, would have understood this not as a popular work. But I didn't mean to debate the issue of the Shulhan Aruch. It's that you set it up as, well, here's this learned thing. Let's now go to the Shach. The issue has been raised here. Elishever raised the issue. Look, after all, this is something that everybody knows about. And Shchita is an interesting thing. I can think of Chaim Hillel ben Sasson Manoach's point that Shabbos, everybody knew Shabbos, but you still write books about Shabbos, right? And it doesn't mean that it's an indication of what real practice is because somebody's put out a new Hilchos Shabbos book, right? It's something unique. So what we have here is a kind of a standardized knowledge, which presumably was practiced very widely, and even though there are highly specific rules about shchita and very arcane rules that you have to know this, that, or the other detail, the fact of shchita was that there were guys with big arms and big shoulders who were butchers, and they brought the shochet in, and they would tell him, now look, this is the animal, and if a shochet screwed up, they beat the hell out of him. And this, we know that shchita is always one of the big issues in community, not just in terms of control from the top, but also who trusts that butcher or that shochet. And this is a fighting issue that has remained a violent and often corrupt issue in our communities down to the present time. In that context, when you look at the Shach, and I don't know the Shach well enough to comment on the Shach generally, but here, what they're talking about is a theoretical issue about the nature of brachas. They're saying, does a bracha, is it, something that's chiyav on the man after? It's sort of like being here, I suppose one should say, the Rav's kind of presentation following the Volozhiner method of kind of theorizing halachic practice. The Shach, it may be that the Shach, therefore, was not followed, not because he is quoting Sfardim or not quoting Sfardim, but rather that there is one level of discourse, which is the everyday discourse of psak halacha, what do you do? And then there is this guy who's all of a sudden raised new theoretical issues, and if you read the discussion, it's an endlessly complicated discussion about the nature of the act of saying a bracha and whether it applies the same to all kinds of items, whether food consumption and mitzvah doing are different. So he creates this intellectual world which remains a dead letter, not just because it's Sephardic. I'm not denying your point. Your point is obviously well made, but I'm wondering to what extent it is that what we're looking at here is a totally different context of discussion. That is, the Shach is doing a nice theoretical, analytical, I would say constitutional if I weren't surrounded by people who really know what that means. But, he's talking about a nice academic thing. And it's really irrelevant, not because they're Sephardic, but because very nice. In yeshiva, you'll go learn that, but now you're irrelevant.
Lois, Adam, Ari, and if we have time.
I'm interested in knowing more about the 18th century and when you said the Sephardic legal authorities were brought into Ashkenazic legal discourse. And it seems to me, based on the last few comments, whatever point you're looking at, there's a set of, there's the legal discussion, the substance of the legal issue itself, the question of authority and which sources seem kosher or not, interesting or not, forgive me. But there's also, I don't think you can avoid the cultural, historical questions of, contextualizing that moment in the cultural, social reality. So why there might be more openness to citing sources from another cultural area, or there might be resistance, and questions of that sort.
In terms of what happens in the 18th century, in the 18th century, there's essentially an explosion of printing of Sephardic sources that begin with commentaries on the Talmud. Essentially, printing of the Ramban, the Rashba, and the Ritva. So that begins in about, I don't remember, 1705 or 1708. That's the problem of a hay and head, remember. But, it's just a little difference between them. But the first decade of the 18th century, that begins. They enter the mainstream of Talmudic commentaries. When they enter the mainstream, plus we get changes that develop in reaction to Pilpul, and something that Yisrael Tashma is discussing. When we add to that these new ways of study that come, so then there's an openness to new ideas that come from new sources as well. So we have the sources are widely available printed. I think we're not talking just once or twice, we're talking dozens of times these works get printed. So they become used, they become taught, they become part of the ongoing study. And then that continues as these people get older and broadens. Cultural context, it's hard for me to say. I don't know if I were to take other areas.
Excuse me, other what?
Other areas. And this, Murray Rossman has this chapter on cultures of the Jews. He cited, it's not only his, but he cited a new canon of sources that emerges in the late 16th century. And he has a whole list of sources, Sephardic sources that he picked up. For example, commentaries to Rashi. They take them all from the Sephardic world. Those are accepted. Kabbalah. There's nobody that stands up, almost nobody that stands up. We don't want Kabbalah because it comes from the Sephardic world. Law stands communities, I think in terms of self-identity and who we are. Don't forget Kabbalah. It's not just Kabbalah from the Sephardic world. Kabbalah came no less from Shimon ben Yochai, 2nd century. We can't just ignore that and all the commentaries. We didn't know it. Philosophy has a bit of a heyday in Poland. Not a long heyday, but it has a little bit of heyday. But what's it replaced with? Kabbalah. So other areas filter through. Law doesn't.
Yeah, I'll sort of follow on what Lois said. Think a little bit about the historical context, and also what Suzanne said about the gap. You have the Shach writing in 1646, and his methodology, his broadening the source base being picked up in the late 17th, early 18th century. I mean, that's as I understood. But in terms of what's happening in Poland, it's a natural thing. I mean, 1648, Poland plunges into 30 years of war. International connections, the book trade, these are all things that are not working. I mean, it's really a very bad time to have a broad horizon in Poland. The Polish cultural horizons for Poles and for Jews have plummeted, and it's natural in a period of war. So it may not be purely a sort of juristic conservatism. There are other objective factors which are going to prevent that kind of cultural development from happening at the pace you sort of seem to expect it. And maybe revolutions, they're much quicker when you're looking at them from a perspective of 300 years than they are actually when you're living through them. So that's one thing.
Let me reply to the first point. And that's what I've tried to do with scanning sources. Don't forget that rabbinic activity went on, but not in Poland. If we look at someone like Chabad Yoreh De'ah, he's a good example of an Ashkenazi rabbi. And yet, even he's often Metz. We're not seeing anything. Gershon Ashkenazi starts with an Eastern background, but Moravia, off again. I think at the end he ends up in Hamburg. He dies in Hamburg, Altona, somewhere. He doesn't use them either.
Right.
So it's not just, the book is there, the shach is used, that we know.
Right.
Avram Gombeiner also, these people, it's just not getting picked up.
I also, just a comment, you talked about picking up with Elisheva said, the question of Shrita. Shrita does change in the 16th
I didn't say
century.
Shrita doesn't change, just the blessing over Shrita is
No,
not a
you
pressured
you
issue.
said the significance of Shrita doesn't change it, and I think it
What do you mean
does.
significance?
The economic significance of it. You said it. You said we can use Shrita because we can iron
It's always
out.
economically important.
It's much more economically important in the 16th, 17th, 18th centuries for demographic, social and economic reasons where the Jews are. It becomes a major issue. I'm not sure it affects your argument, it's just something you said that I wanted to pick up on. These things, they have a kind of broader context, it's important to see it. And the other thing is about conservatism and the question of print. We do tend to assume there is a printing revolution. And what we know from European history is how it works, and that this is how it should work. I think the Jewish printing revolution was different from the European one. And I think that the Jews picked up on it in different ways. Certain aspects of it they did pick up on, and others they didn't. For example, if you look at the question of organization of knowledge, both within the book and on the page, Jews are very, very conservative about that. There is no revolution in the way the page is organized with the printing revolution for the Jews. The Ramah is writing glosses, and the commentaries appear in the form of marginal glosses. This hasn't changed. The way in which the legal corpus is organized goes back to the Middle Ages. Nobody is radical enough to break down that kind of the structure of the Turim and the Shulhan arukh. That remains. It doesn't change. Print, in European terms, is seen as allowing a change in the way you organize knowledge. So the idea that this conservatism is simply in terms of legal thinking, I would also broaden it a little bit. I think Jews and print have a much more difficult relationship than non-Jewish society and print does. I think it's something that's worth looking at any rate.
Okay, we have 1 minute, so... Ari?
My question actually goes back to the contemporary context, and I think it touches on the issue of the authority that was accorded these sources, say by the Shach at the beginning, as well as the motivation for deploying them. And that is the context in which he raises these sources. Were they being raised? Is there some sort of a trend in which he's raising these sources to fill gaps in the law? Is he raising them to arbitrate between conflicting opinions? Or is he raising them to sort of expand the legal discussion, not necessarily even to arbitrate, but simply to expand the horizons, maybe to go out in new directions, even when there's not necessarily conflicting opinions, but it's essentially something that's supplementing.
Is in that big debate about gaps.
That's right. Certainly he fills in gaps, there's no question. But he also uses to expand debates. You have an example right here, as Bernie basically pointed out. This issue, he didn't have to go off this way. But he didn't like that this guy, Abraham Travis, who's he to challenge Maimonides? And then he has a whole debate that works it out. So you have everything here.
Is this part of the Shach's general methodology where you make them up with
Does he use this and beat him up with it? That I wouldn't.
But he has a methodological approach to the question of gaps. He has a debate about this, and so I think but whether to turn to other sources.
Right. He is willing to turn to other sources. That definitely will turn to other sources. But all those things you mentioned, he does. Not necessarily right here, but I think he does.